Good morning. I'm Gary DeWaal, and this is Bridging the Week for July 18th to 22nd, and today is July 25th, 2016. Last week, CME Group proposed a new clearing membership category to help customers avoid the risk of receiving a prorated allocation of losses of their carrying futures commission merchant in the circumstance of the FCM's insolvency and its inability to satisfy its obligations to all its customers in full. In addition, the Financial Industry Regulatory Authority warned its members not to take advantage of recent court decisions that it claimed were incorrect in permitting member firms to bar customers and associated persons from taking advantage of FINRA arbitration forums to resolve disputes. Finally, two former senior officers of a global investment bank responsible for certain of its foreign exchange trading were named in a criminal complaint filed in a federal court located in Brooklyn, New York, related to the purported front-running of the foreign exchange trades of a customer. A heat wave overcame much of the continent of the United States last week and is not scheduled to leave until midweek this week. So I can go find cooler places to hide. Let's get started. CME Group filed proposed rule changes with the Commodity Futures Trading Commission that would create a new category of clearing membership termed a direct funding participant, or a so-called DFP. Under CME Group's proposal, a DFP could clear all of its eligible proprietary CME Group trades directly with the CME Clearinghouse, but would not be obligated to contribute to CME Group's guarantee fund or otherwise be responsible in case of a default by another clearing member. Instead, all of a DFP's obligations, except for obligations arising from disciplinary actions against the DFP, to CME Group would be guaranteed by at least one other clearing member termed a DFP guarantor that would also be a CME Group clearing member and be registered with the CFTC as a Futures Commission merchant. DFPs would settle their margin requirements directly with the clearinghouse. However, if they did not, their financial obligations would have to be met by their DFP guarantor. According to CME Group, in its submission to the CFTC, the purpose of its proposed initiative is, among other things, to eliminate the possibility to a customer of receiving a prorated loss allocation in the case of an FCM bankruptcy where the FCM was left with insufficient resources to satisfy its obligations to all its customers in full. In addition, CME Group claimed that its proposal could help an FCM by eliminating the posting of cash by a DFP on its balance sheet and thus the possibility of a potential increase to the FCM's regulatory leverage capital ratio. CME Group's DFP proposal is scheduled to take effect on the earlier of September 23rd or upon CFTC approval. The Financial Industry Regulatory Authority issued a regulatory notice to member firms last week that warned them against eliminating the possibility of a FINRA arbitration in contracts with customers or associated persons, despite recent court decisions that said that member firms could eliminate such availability. According to FINRA, under its rules, member firms must offer customers a right to arbitrate disputes with them at a FINRA arbitration forum. Although acknowledging recent federal court decisions that held that form selection clauses in customer agreements supersede FINRA requirements, FINRA claimed that, quote, the reasoning giving rise to these decisions is mixed and conflicts with FINRA's views regarding the application of its arbitration rules, end quote. Similarly, FINRA noted that a recent federal appellate court decision in New York held that an associated person could waive his or her right to a FINRA arbitration in a pre-dispute agreement and agreed to resolve all disputes with the member firm in a private forum. However, FINRA claimed that the court view was inconsistent with its own rules. FINRA warned that member firms with customer agreements or pre-dispute agreements with associated persons that do not comply with its requirements, quote, may be subject to disciplinary action. That seems pretty serious. The infamous history of MF Global is closer to ending after the administrator for the bankrupt holding company filed a proposed notice of settlement that, if approved, would provide a payment of $132 million to resolve most outstanding litigation against the company and individual former officers. Most of the funds would come from insurance proceeds from policies maintained on behalf of the former officers of MF Global that was named as defendants in the litigation, including John Corazine, former chief executive officer. An unspecified amount of funds, however, would be set aside to help fund the defense costs of Mr. Corazine and Edith O'Brien, former assistant treasurer, and any possible fine in connection with their pending enforcement action by the Commodity Futures Trading Commission. A hearing on the administrator's proposed settlement will be held on August 11th. And finally, Mark Johnson, former head of Global Foreign Exchange Cash Trading at HSBC Bank, and Stuart Scott, former head of FX Cash Trading for HSBC for Europe, the Middle East, and Africa, were named in criminal actions brought by the U.S. Attorney's Office in Brooklyn, New York, for allegedly front-running HSBC's customer trading in British pounds in November and December 2011. Mr. Johnson was arrested in connection with this complaint on July 19th. According to the criminal complaint, both individuals purportedly conspired to trade on information confidentially provided to HSBC by an unnamed customer that planned to sell part of its interest in an Indian subsidiary for $3.5 billion US, and then convert the sale proceeds to British pounds for distribution to its shareholders. In October 2011, HSBC was awarded the mandate to arrange this conversion after the company conducted a request for proposal process involving 10 banks. HSBC allegedly gave both defendants access to information regarding the proposed foreign exchange conversion and officially deemed them insiders. As insiders, alleged the complaint, the defendants, quote, knew they had an obligation not to misuse the confidential information, including by front-running, end of quote. Instead, said the complaint, defendants established their own British pounds positions in HSBC proprietary accounts to take advantage of the customer's impending currency conversion and orchestrated the customer's actual currency conversion in a manner to maximize their profits. According to the U.S. Attorney's Office, HSBC profited approximately $8 million US as a result of its execution of the FX transactions for the company, including from defendants' allegedly illicit conduct. The defendants were charged with conspiring to defraud a client. Well, that's it for this week's edition of Bridging the Week. As always, there's more information in each article and more articles on the article version of Bridging the Week on the website. Check it out. I'm Gary DeWaal. Until next week, have a great week and ciao.